Can health insurance companies get reimbursed after a personal injury paid out? You fought hard for your personal injury settlement. But before you see a single dollar, the law may require that certain insurers and government programs get paid back first. Virginia law generally protects injured people from private health insurers claiming reimbursement out of a personal injury settlement. But federal programs operate under an entirely different set of rules. This distinction between state-protected private plans and federally governed programs is the difference between keeping your full recovery and handing a significant portion of it back. The legal mechanism behind this process is called subrogation, which is an insurer's right to seek repayment from your settlement for medical bills it already covered on your behalf. Virginia Code Section 38.2, 3405 prohibits most fully insured private health plans sold in Virginia from including subrogation provisions that allow recovery from your personal injury payout. This protection exists because an injured person who already paid insurance premiums should not be forced to repay those same benefits out of a hard-won settlement. However, federal law can override Virginia's anti-subrogation rule, which is why understanding exactly what type of coverage you have is critically important before accepting any settlement offer. Programs like Medicare, Virginia Medicaid, TRICARE, and self-funded employer ERISA health plans all retain the legal right to recover costs they paid for your injury-related medical treatment. Medicare operates as a secondary payer under federal law and has a statutory right to be fully repaid from your settlement for any conditional payments it made after your accident. Virginia Medicaid can assert a lien for injury-related medical expenses it covered, and federal law permits recovery from amounts allocated to medical care within your settlement. TRICARE, which covers service members and their families, also carries a federal statutory right to recover costs for injury-related treatment from any at-fault party settlement you receive. Self-funded ERISA employer health plans may enforce written reimbursement terms that completely preempt Virginia's anti-subrogation rule, as confirmed by the U.S. Supreme Court in the 2013 U.S. Airways v. McCutcheon decision. A related concept called the made-whole doctrine holds that an insurer cannot collect reimbursement until an injured person has been fully compensated. Though this principle does not override federal programs or statutory liens in Virginia, liens, subrogation rights, and reimbursement obligations are distinct but related mechanisms that can each reduce the net amount you actually take home after a settlement is reached. A knowledgeable attorney can identify every valid lien attached to your recovery, notify the appropriate programs, and work to challenge or reduce those amounts before funds are ever dispersed. The experienced lawyer team at GibsonSingleton Virginia Injury Attorneys, including Ken Gibson and John Singleton, helps injured Virginians understand exactly what will be deducted from their settlement before they ever agree to accept it. This law firm serves clients across Gloucester County and surrounding Virginia communities, fighting to maximize every client's true net recovery by resolving liens wherever legally possible. If you were hurt in Virginia and want to know what you may actually keep from your settlement, contact the trusted legal team, another dedicated Virginia injury law firm, GibsonSingleton Virginia Injury Attorneys, at 804-413-6777, located at 4073 South George Washington Mem Highway, Hayes, Virginia 23072, United States, and schedule your consultation today.